Are you ready to probe into the complexities and legalities of MiCA or markets in crypto assets regulation? Join us at the block as we unravel the intricacies of crypto legality. But first, let's set the stage. Did you know that the EU's MiCA regulations are reshaping the landscape of blockchain and digital assets? It's globally discussed topic, and today we're privileged to tackle it with an expert from Icon Partners, a leading legal firm on blockchain innovation. Here at The Block, we're all about providing unique insights. Stay tuned until the end of this episode for an important announcement about privacy and security. Let's dive into MiCA and its impact on EU and the global crypto market ecosystem. Only here at The Block, brought to you by ICORBP. Our subject matter expert has years of experience in the cryptocurrency and blockchain space and is currently working with Icon Partners, an EU-based law firm from Estonia. Without further ado, let's bring in Anastasia Kosov.
Hello. Thank you so much for having me here. I'm ready to get started into this topic. So, you mentioned the way this about us. So we are really introduce Icon Partners, Estonia-based company. We operate in 40 plus countries. We serve different clients. Valuated from 200 euros even to $3 billion. Here, different kinds of clients. And usually we speak about kinds of businesses. It's IT, fintech, blockchain, and e-commerce businesses. So lots of them. Especially I am a legal division lead. So we are leading 30 and more projects nowadays. And this, the main tips maybe about our company, so I should mention. So maybe let's get started with MiCA regulation and discuss its peculiarities, since we have lots of things to discuss today. Yeah.
Before delving into the specifics of MiCA, maybe let's start at the beginning to really understand what MiCA is, or marketplace in crypto assets, how it originated, where it applies, and its significance in today's financial landscape. So, to kick things off, could you provide our listeners with an overview of what MiCA is, how it came into existence, and the reasons rationale behind its implementation? Essentially, what prompted the creation of MiCA and what objective does it aim to achieve?
So it's reasonable to start some overview. MiCA. All the holding is the regulation on markets in crypto assets. And this is the first legal act created in the EU just to regulate crypto assets on the EU area. And if previously there were lots of different legal acts in different countries with different requirements and even with some inconveniences between them, yeah. So it wasn't so convenient for market players. But now it will be one basic framework that will regulate it, this sphere. And, as authors of the MiCA expect, so it should say, and it should set the certainty, the transparency for the whole market. But from my perspective, it will also add some additional obligations for the market players, but we will see. So, by the way, I still will, since the regulation, maybe maybe our audience know, was adopted in 2023, but it will fully enter into force not later a bit, fully in December 2024, but with the exceptions of two sections that will enter into force this summer when we speak about second and third sections. And just to talk about the context of MiCA, I should say that it really covers a lot of questions regarding the crypto assets. By the way, it doesn't regulate NFT with some exceptions, which also constitute a significant part of crypto assets, but still, it nevertheless regulates towards other types of crypto assets, set their definition, specify their peculiarities, and what is important, MiCA introduces the regulators, and set particular requirements like general rules of game for the market participants. So that's like a big step forward, I should think.
Thank you for that. That's a great overview of what MiCA is. And as we all know, one problem with cryptocurrency is adoption. And I guess with regulations coming in, it's easier for people to adopt what cryptocurrency is. I guess the next question is building upon the understanding of MiCA's origin. Maybe we could really dig deep into the scope and applicability. Where does MiCA apply, and why was there a need for such regulation in these particular jurisdictions? What specific challenges or issues within the crypto asset market does MiCA seek to address?
Yeah, I agree. It's reasonable to start with that question because everything we're going to discuss reference to MiCA is these types of crypto assets that are regulated by MiCA. No? And if we check the structure of MiCA, or even if we check the Article 1 and of MiCA, so we see three big groups, three different groups. And MiCA classifies these three groups depending on the risks these crypto assets entail, and also it will be also about some requirements for market players a bit earlier, later. So, and if we speak about these three groups, we see the first group. And the first groups, it aim to stabilize crypto assets, that aim to stabilize their value by referencing. And here we should be really attentive, not to be confusing later. We should be attentive. This type of crypto assets aim to stabilize their value by referencing only one official currency. So in this first type, I'm talking about e-money tokens. Like first type. And they aim to stabilize their revenue by referencing only one official currency. And, if we speak about them, they are very similar to the function of electronic money as defined in another directive, another legal entity by Directive 110 that was adopted in the EU in 2008. But these e-money tokens, they are like some surrogates, plotting surrogates for coins and banknotes. And this is the first type. So the key thing for them is aiming to stabilize their value by one official currency. But it's the first type. The second type, it's asset reference tokens, the second type. And they also, like e-money tokens, aim to stabilize their value, but again, attention. So referencing another value or right, or combination thereof, just included one but not limited, one or several official currency. You see? So in that second type covers all other crypto assets that are like backed by some value, except e-money tokens. So it was done just to avoid such a convention and to make this regulation future-proof. So everything that is based, with exception of e-money token. That was the second type. And the third type, it is about crypto assets other than e-money tokens, the third type, and asset reference tokens, the second type. And really huge range of different type of crypto assets. Also, so just to make it clear, like utility tokens here, well publicly known, also they fall under this category. So this is about the three main types of crypto assets.
Now, talking about just to make sure if I got right, for number one, I'm more focused on the first type of asset to make a reference on a specific coin to make it stable. Are we talking about a stable coin, for example, USDT, or what is the coin that is referenced to make it stable?
Yeah. You see, if we speak about USDT, it will be about the second type, asset reference tokens. But about e-money tokens, like the first type, it's about the surrogate for one country and like surrogate for official currency of this country. We cannot say that it was already developed in some European countries, but there are lots of different talks about that, even in Poland, even in Ukraine, also talk about such things like surrogates for official currency of the country, yeah. So that's why it's important to understand. We don't know how it will be. We will see under after the regulation entered force, but still. So use the pair just the second side as its reference token because they are backed here by official currency, but they are not backed only by USD, as to know. Say there are other they also need to be backed with.
Is it safe to say CBDCs? That could be the first type that is issued by a specific country.
Maybe yes. Yes, I guess.
Thank you for that clarification. Moving on, the attention on the regulatory framework of MiCA, we understand that it covers those different types of assets. However, are there any exceptions or specific types of assets that fall outside the scope of the MiCA regulation?
Yeah. You see, if we speak from scientific even perspective, yeah, there is two main approach how legal acts are wrote. And because of that, the first approach is just to specify the particular types that is regulated, or another approach just to say that everything falls under the regulation, but with exceptions 1 to 3. And MiCA used the second approach. They said this, everything are there, but with particularly specified exceptions. And we have such exceptions. First of all, I mentioned NFT. Yeah, non-fungible blockers. So they do not fall under the regulation. But here, again, we have exception when MiCA may be applied. So this is the situation when NFT has characteristics similar to the regulated assets. For instance, if NFT tokens they issued in large series, and they are interchangeable, may be considered interchangeable. So in this case, they may be considered like assets that fall under regulation, but not in usual cases. It's like much more as exception. And another big group of situation, when assets they also will not be covered by MiCA. It's crypto assets regulated by other EU financial services laws. So we're talking about the existing framework here, such as assets qualifying as financial instruments, pension, or some insurance products. But even so, I should say that the regulated segment is still quite high, really. Although there are some nuances, and we also should take them into account. That's why just to determine whether your product, whether your asset falls under MiCA regulations, and you should also follow some requirements, here really a thorough legal analysis is required. So that's why our clients, before entering the market, they come to our lawyers, and we conduct a pre-analysis, of the product, of the situation. We see if there are some exceptions that may be applied to this particular type of crypto asset, just to avoid authorization, other requirements, and so on. That's why I think that actually some audience businesses, you may come, for instance, for our clients. By the way, we have extensive expertise in this sphere, like dealing with some legal complexities of Web3 technologies, crypto technologies, or you may come to other labs. But still, what I'm trying to say that it is the really a priority issue for the business before entering the market. You have to understand if it falls under the regulation or not.
This is a stupid question. Let me just ask this. How does MiCA classify a meme coin? For example, Pepe coin or Shiba or Dogecoin.
Yeah, so since it's not false, it is not like baked, with some, this is classified as assets other than e-money tokens and asset reference tokens, like the third group,
Mm.
Yeah.
As MiCA places obligations on various parties within the crypto asset ecosystem, such as offerers and issuers, could you elaborate on the specific obligations that they have, particularly concerning those different types that you have described on the crypto assets?
Yeah, thank you for the question. So, also just to understand which main groups we have here, and that's fall under the regulation. So we just can check the article 2 of the regulation of the MiCA, and just let me quote to be much more precise. So MiCA is applied to natural and legal persons. That's first big group that are engaged in issuance, offer, or admission to the public of crypto assets. This is the first group, and the second big group it's that's just also natural and legal persons that provide services related to crypto assets. Two big group, issuers and offers of different types of crypto assets, regulated crypto assets, and crypto assets service providers. And, just to start with something that is easier, maybe we'll start from us. First of all, crypto assets service providers, At here, MiCA set the full list of crypto asset services, and the main of them, it's like the operational trading platform, exchange for fiat and official currency between different, for exchange for fiat and crypto assets, or exchange between different crypto assets. And even such a service like provided advice on crypto assets, So that is about crypto asset service providers. And the main requirements here are, first of all, why we all are talking about MiCA, it is because now they need to register an office in one of the EU member states, and obtain a service provider authorization. There are also other requirements, like to have a minimum authorized capital from 50 till 150,000 euros, depending on the type of services they provide, or even fulfill some obligations to comply with fast rules before making a transactions. And for this group, we're talking about trading platforms like Binance, Oil, Kraken, such different types, or different exchanges, for instance, Ramp or MoonPay. This is the first big group. And the second big group, it was what we mentioned before, issuers and offers of different types of crypto assets. And MiCA directly says what is it. So issuers means natural legal persons that issue crypto assets, yeah. But offer is also a natural legal person that issue crypto assets to the public, yeah. So, and if we analyze the provisions of MiCA, we will see that in most cases, I say most because there are also some exceptions as usual, but in most cases, issuer and offer may be like the same person or different persons. So it's important from their perspective. But still, such two big groups. And of course, there are lots of different requirements for this group for issuance and offers, depending on the risks their crypto assets that they issue and offer entail.
What is the stand of MiCA for decentralized exchanges?
MiCA, it's about, it is not covered. Yeah, it's about an exception. So in the same situation as we had some exceptions for crypto assets that doesn't fall under MiCA regulations, the same thing we have with main players. So the first exception is DeFi, as you mentioned, Jan, the first exception. Also, we have exception like CASP, but CASP not as we discussed, but specifically those who are operating for the affiliates, liquidators, and administrators in bankruptcy proceedings. And also we have public international organizations here. And as I remember, we have some financial institutions, for instance, European Central Bank, or national central banks, also etc., similar institutions. So these players, they are not regulated by MiCA, but they are out of scope of MiCA regulation. So yeah.
Talking about issuers and offers, for example, if there is a charity coin who wants to be introduced in EU and it helps different nonprofit advocacies, how should that, for example, a person wants to issue or give those coins to a church there in EU? Does it fall under the regulations or control of MiCA, and what are they supposed to do?
The new regulation in different spheres, not only in crypto asset market, have the same approach. If you provide services or sell something to EU customers, like EU residents, if you deal with them, so you will fall under the authorization, under requirements if they exist, and that's the situation. But these requirements, they also depend on the type of crypto assets you issue and offer, because there are different level of risks. For instance, if we are talking about just the easiest situation, assets other than asset reference tokens and e-money tokens, so there is no particular requirements for the issuer. But there are some requirements for the offer, and there is no requirement here to have a legal person in the EU, no. But still, you should be a legal person, at least, only in the world. You should have a white paper, like technical documents, about your crypto asset, on your website, and you have marketing communications and have some also information. And of course, you will be liable in case some incorrect information is provided and it causes some damages, either by paper or marketing communication. This is the easiest situation here. But the situation can be much more difficult if we said about issuing or offering offering crypto assets, other types like crypto assets that are like abstract tokens and e-money tokens. And here you speak about offering of extravagance tokens, you will need additionally to that we mentioned previously for the previous type, you will also need to have an office in the EU, so you will need the company. And that is the requirement, you see. And also you may have some additional obligations, so you will need to have office and located in the EU, and you will need to have authorization. What's why we are talking about that? So you will need to have a license. But there were advantage, because previously when we didn't have MiCA, there was a need to have a license in each country. If you want to enter the EU country, EU market, so it was needed to go everywhere, to go to Latvia, for instance, Germany, to other countries. So you're going to provide services to locals. But now you will receive one license, like authorization, and you will be entitled to provide your services, or to, if we're speaking about offering issuance, so you will need to sell your tokens to local customers. And that's about Astra's tokens. So, and also the same obligation for the issuers of asset reference tokens to have white paper, to have marketing communication, to rely on incorrect information. And as for issuers and offers of the third group, EI tokens, we talked about previously. And here it is about the exception that I previously mentioned, when we have the situation when the offerer must be an issuer, you see. So I said that in most cases it may be both the same person or different persons, but now we should have the same person. And they also should have authorization, but specific authorization that is much more difficult to receive than authorization for offers of extra tokens. I'm talking about license of credit institution or a known as electronic money institution. So the whole they also need, but the same thing, white paper or marketing communications again is required. So that is this,
Thank you so much for that. So that one thing that I could see is, before going into EU with the business on cryptocurrency or crypto assets, they should look for a law firm that would help them, guide them, navigate, and not just go in and start their own business. The next question would be, while MiCA really aims to regulate many aspects of the crypto asset market, are there any entities or activities that not be directly covered by the regulation? And if there are, who are these players, and how do their activities fall outside the regulatory framework being established by MiCA or MiCA?
So, sorry, I have some interruptions to the connection, some troubles maybe. Am I right that you asked about regulators? Yeah?
Yes. Well, you have MiCA to regulate the different aspects of the crypto asset market. Now, are there any entities or activities that are not directly covered by the MiCA regulation? And if there are, who are these players, and what are their activities that fall outside the regulatory framework established by MiCA?
You see, that is what we talked about when we have some exceptions, for instance, some types of crypto assets, that's and also that do not fall under the regulation, and some key players. And here we have two situations. For instance, if we talk about NFT, it is not regulated yet. It isn't regulated. And they still should to think about that and to regulate it in some way. But it seems to be difficult for now, but still they will do that. Or another type, we already have different legal acts that regulate some types, like, for instance, security tokens. Yeah, they are already regulated by some securities legislation on the EU arena, and that's why there is no need to be covered by MiCA, because there are some direct requirements here. So that's about exceptions here.
You did mention about the e-money or electronic money tokens. Maybe you could expound more, wherein MiCA distinguishes between secured and unsecured assets with provisions addressing e-money tokens. How does MiCA differentiate between these asset types and how e-money tokens specifically treated under this framework? I think you did mention this a while ago, but maybe you could expound more, please.
Okay. So regarding security, there are lots of questions here. At least two I see. Regarding the security tokens, they are not covered by MiCA regulation, as you can see, because they are already covered by another directive, also legal act of the EU, that regulates all these aspects here. So, it's a much more difficult situation, special kind of crypto assets that also require special additional requirements, yeah, and they are previously regulated. And as for the first question you mentioned, could you repeat that one more time? So the first question.
It was more about the security and unsecured assets. How are these being differentiated?
So I understand now. Yeah, unsecured assets. It's like the same thing. We just the question of terminology, like we have crypto assets, or we may also call that virtual assets. Yeah, and the same thing, unsecured assets. It's the type other than asset reference tokens and email tokens. When there is no, then these types or type of assets is not backed by some value, right? Official currency or so on. And that is about unsecured assets. Yeah, this is about the third side. As I mentioned, the most common type is utility token. Yeah, when there is no, so it is unsecured token. There is no some value that can let's say, yeah, and amount in the value or maybe redeemed. Yeah, so there is some type of risk here. That's why it's about it. But secured are not under regulation, as I mentioned. I mean, under my regulation.
Regulatory regulatory oversight. That's what MiCA does. It is really crucial for maintaining the integrity of the market. However, my question would be, who will serve as the primary regulator under MiCA, and what level of influences are they expected to exert over the crypto asset market? And to add with that, what are the penalties if somebody violated MiCA regulations? Is this a criminal case? Is it a civil case?
Yeah. Okay. So regarding the few things, what I want to say here. The first thing about regulators. Yeah. So we have this regulators who provide authorization. They it's about national services, national organs on the national level. And also we'll have two additional European institutions like EBA and ESMA that will also have some supervisory powers. But talking about some penalties and punishments, so we also have MiCA directly specifies different types of penalty that market players may have in case they violate their provisions of MiCA. And first of all, it's about what these fines are imposed by national organs, but these EU organs then may advise or requires also to do that. And it's about penalties, so really huge penalties. Their amounts depend on the type also of crypto assets, and they depend also on their on their situation, so on the type and on their market player also. Like is it a natural person or it is a legal person? Because for legal persons, of course, the fines will be much more high. And except of these fines we are talking about, there also may be some administrative measures imposed on some violators. For instance, that they may be required to, or even prohibited to continue the activity. These EU supervisory bodies like PP and ESMA, they may also put them into special list of violators. Also, so it's about some public reputations, for them. So this is about different types. So that's why just to play and not to require to receive authorization is not a good fit here. The regulator was thought about that and specified particular big fines, not even thought about violating the provisions. But what I should say is, of course, there is some work for lawyers here, because there are somewhat nuances, legal nuances we can analyze. When, as I already mentioned, when MiCA regulation may not be applied. For instance, if it's too small business, there are some limits for that, or other exceptions. So that's why what I was trying to say previously, and a little bit more one more time. So pre-analysis is the key. Just to see it, to analyze the products, all requirements, and to find maybe there is some nuance that will help not to spend time for receiving authorization, license, and so on, not to make it too complex for the business.
Are there any companies at present, right now, who are your clients that you're currently helping with?
Our clients, they usually go to us. We make reanalysis and then they enter into the market. So, and what we also mentioned that MiCA hasn't entered into force yet. Since it was adopted, but it will enter into force only in
December 2020.
But two sections are in July and in June, in summer, let's say. But all of our clients that are going to enter the EU market or already work in some separate countries, they are worried about that, and they come to us and ask what to do, what we will do after it will fall into force. So that's why we make analysis. We are waiting even right now to analysis here just to provide them with reasonable legal approach here.
It's really good to have this wherein you have this pre-analysis, making sure that everyone is within the bounds of what the regulation is. Insider trading, I guess that's one of the main concerns in financial markets. How does MiCA address the concept of insider information? What measures does it implement to prevent any abuse and uphold market integrity?
Also an interesting question. I was waiting you to ask that. Really about insider information. You see, generally, as we previously talked here, so what we need to do, what the issuer and the offerer needs to do, it needs to provide their customers with the information. So who you are, the offerer or the issuer, who you are, what your legal entity, or do you have some legal entity? Yeah, just to make it clear for the customers, for the buyers of the tokens, with whom they deal. Yeah, information about you. But that's the general rule. And of course, there is an exception here when issuer or offerer do not want to make some information public. For instance, some developments plans here. And for such cases, MiCA specified that and provided for such category of information the special name like insider information. So, and issuers was entitled not to make this information public, because if it will be known, wide known by public, yeah, their prices of their crypto assets may be much more loyal, yeah, will be much loyal. And that's why MiCA prohibits, first of all, let's say it allows not to tell about such situations, about such information, and prohibits using of such information by third parties. For instance, some counterparties, they know about that, but of course, we have some provisions. But what is interesting that there is no sanction for that. There is no sanction in MiCA. So that's why we will see if it will be. Yeah, interesting. We will see how it will be.
I would like to thank you so much for giving clarity on what MiCA is and how it will be implemented. And those things are very important, especially for those who want to do business in EU with crypto assets. Zooming out to the broader context of Europe and the global crypto asset market, are there any specific changes that the crypto projects anticipate in response to the implementation of MiCA this December of 2024?
Just to sum up everything, I would say that, as we mentioned, MiCA really sets some comprehensive requirements here for most crypto assets market participants in the EU, but also in the other parts of the world, because if you want to work in the EU, on the EU market, so you will need to also follow some requirements, and that's the key. So token issuers, offers, crypto asset service providers must fulfill a number of requirements, such as we mentioned here, to have legal status in the EU, to have minimum share capital, or be liable for providing incorrect information, and so on. And all of this aims to create some safe and transparent crypto asset market, but also may increase the complexity before you enter the market. Because we mentioned that before there was different countries, EU countries, different laws there, and some inconveniences between them. So, and MiCA will help to make the market more predictable, because before you see, okay, this year EU country, normal legislation on the national level, but we don't know what will be tomorrow. So they put some money, the business owner put some money into this market here to develop too. But tomorrow we could have some new regulation, and we don't know what to do. But now it will be predictable. So regulation is not going to be changed every month. So it is some provision, and we'll have this predictability. And of course, but the same thing for the business, offers, issuers, there are some requirements. So if you want to have the market predictable, you will need to follow some rules, rules are the key. And that's another side of the coin here. But also, we have the better situation for the investors and the private investors here. So they will be much more protected for the customers, like customers of different trading platforms and so on. They will know about some market players here. They will receive correct information about them here. They will be provided by rights to receive their money back in some cases and so on. So the right to redeem also is specified in MiCA. And from that perspective, we're also talking about the protection of consumer rights, So MiCA will add all these fields under its insurance, of course. So, but the same is usually, how it will be, we will see in practice. Or on the banner, we will be able maybe to provide some unequivocal, answer.
Are there anything that you would also add, things that I missed asking, and then also invite our viewers where they would be able to connect to your law firm, Icon Partners, social media handles? If I think LinkedIn is the way to go. What's your website? So go ahead, please.
Yeah. So I think that we have covered the main questions that we should discuss. Thank you so much. I really enjoyed our conversation. Thanks for interesting questions that you asked regarding Icon Partners, our company here, and our where you can find us. So you just make usual thing, Just type icon.partners into Google search, and will be the first link. So we have our own website, we have our LinkedIn page. Maybe the organizers will add the link somewhere here, a little bit earlier. But you may just remember www.icon.partners. So, and you will find us, you will find our blogs. So we shared our some legal analysis regarding MiCA and other interesting things about our activities. So go ahead to find us and figure to contact us if you need some legal analysis. So you will be in contact.
Thank you so much, Anastasia and Icon Partners, for sharing insights on MiCA regulations. If you find value in what we're doing, help us support the channel, and don't forget to like, share, and subscribe for more insights on blockchain innovation. Let's shift our focus to security and policy. Identity theft and data breaches are rampant, with 1,473 reported breaches in the United States in 2019 alone, exposing over 164.8 million records. ZKP's, or Zero Knowledge Proof, offers a solution. Join our next episode, Watch Right Here, with Professor Mohit Vashish to explore how ZKPs enhance transaction privacy and authentication in the blockchain.
This blockchain continuing education program is brought to you by our major sponsors: HTML Coin, utility coin beyond the hype; Altash University, your online school in the fourth industrial revolution; Libra Codes, take control on your NFT creation; and Credence Hub, verified credentials, anytime, anywhere. We also would like to thank our partners,